Okay. Thank you. We're going to take up item 6, AB 722 Perea.
Thank you, Madam Chair and members. Let me begin. I know the chair isn't here, but I would just like to publicly acknowledge him and his staff for working so hard to try to find some consensus on this bill. I know it wasn't an easy lift, and so I just wanted to say thank you for that, and we're excited with the opportunity to move forward. So let me also say that I will be accepting amendments 2 through 7 that are highlighted in the analysis. So startup and small businesses are the engines of growth and employment in California. AB 722 would allow California companies to conduct equity crowdfunding offerings to raise seed capital of up to $1 million while also providing investor protections. It requires companies to file a crowdfunding application with the Department of Business Oversight for a permit to sell securities to investors residing in California. AB 722 recognizes the resourcefulness of California's entrepreneurs, enables them to use modern communication technology and social networks to raise the seed capital necessary to prove a concept, validate a technology, or build a prototype in order to attract follow-on rounds of capital from institutional capital sources. AB 722 will help small businesses get the capital they need to be successful to create jobs and contribute to our economy. I would like to respectfully ask for your aye vote, and I have 2 witnesses here today. Thank you.
Good morning. I'm Scott Houghton, President and founder of Small Business California. An interesting report came out a couple of weeks ago from the SBA Small Business Advocate, and they indicated that over the last 20 years, there's been a 27% reduction in small business loans. Seed capital is really important for small business, and right now it's not available under venture capital. Angel capital is a way to get to angel capital, to give them seed money to get started. We think this is a very important bill that provides investor protections with the Department of Business Oversight reviewing the information, putting a cap at $5,000, giving legal fees. So we do think there's investor protections that don't exist in the jobs bill back in Washington. So with that, I ask for your aye vote on 722. Thank you.
Good morning, Chair, and Chair is not here yet today, but members, Lori Kammer. I, too, also represent Small Business California. I'm also here on behalf of the National Association of Women Business Owners, who actually have their lobby day up here in Sacramento, so many of you will be hearing from the 150 or so that ended up coming into Sacramento today. AB 722 has been a great bill for us to work with. As many of you know, banks are not lending to small businesses. We look at this as another option to be able to responsibly look at locating capital, trying to get capital. There are a lot of protections in this bill. You're always going to have scamming in the world. This bill is not about scamming. It's about helping small businesses, legitimate small and startup, union and non-union companies to be able to access capital. We respectfully ask for your aye vote. Thank you.
Thank you, Madam Chair, members of the committee. Jeremy Smith here on behalf of the State Building and Construction Trades Council. Here in support of the bill. We are not usually in the business of carrying the water of the contractors that employ our members, but today we will kind of in a way, because if these small contractors that employ construction workers primarily in the state cannot get access to capital to expand, they can't put our members to work, both union and non-union. 80% of our contractors, of the contractors in California, are small businesses and would benefit from this bill. So we're happy to be here to support for those reasons. Thank you.
Thank you.
Good morning, Chair and members. Ken DeVore with the National Federation of Independent Business. Our small business owners lack the ability to get capital to invest in their businesses. Banks aren't giving loans, and this bill is an excellent step, an excellent tool for them, and it's much stricter than the federal standards, and we ask for your support.
Good morning, Madam Chair and members. Yolanda Benson, representing the California Asian Pacific Chamber of Commerce. For the reasons stated, we're moving into an innovative financing kind of era. Banking is not the way you get loans anymore. It needs to be more innovative, and we believe this is an option for small businesses.
Any other members in support?
Good morning, Mark Herbert with Small Business Majority. A strong support of this bill. On behalf of the millions of small businesses in our state, I encourage you to continue to give the entrepreneurs the tools they need to be successful, and we strongly support Assembly Bill 722. Thank you.
Anyone else in support? Anyone in opposition? Witnesses in opposition?
Thank you very much. I'm Prescott Cole, Senior Staff Attorney with Cantor, California Advocates for Nursing Home Reform. And while we're very supportive of small businesses, we're very aware of financial abuse, especially financial abuse of elders. We're very concerned with this bill because what it does is it opens up a whole new avenue for those who would target seniors with bogus investments. Now, my 19 years of experience with California Advocates for Nursing Home Reform has made me intimately familiar with the plethora of different kinds of scams that happen. Now, what this bill does, it allows somebody to come in to invent a business as an investment and then go out into the community and raise $5,000. What the bill says is you can't do these telephone soliciting. However, you can make seminars happen and you can reach the public in various different ways. We know that the elders are making a lot of the decisions based on emotion, and a lot of them really want to get that rich quick. Now, the problem with the bill is, even though it does try to get to consumer protections, the protections that actually they're offering is really a barrier to recovery, because no investor will be allowed to invest more than $5,000. And I'll tell you this, it's virtually impossible, if not impossible, to find a civil attorney that's going to take a case for $5,000. It doesn't happen. The costs of litigation are such that you just won't go. Even attorney's fees and costs. $5,000 is an invitation for a predator to go out. You know, cumulatively, it's going to be $1 million. You're going to have 200 individuals out there that have a $5,000 investment. Who's monitoring, who's doing the oversight, who's looking at this, and in the very end of any kind of investment, obviously if there's going to be a lawsuit, it's going to be a lawsuit because the investment failed. And if the investment failed, there's going to be nothing to get back for the victim. These ventures are going to be judgment-proof. So what we're asking seniors to take a risk on something that is really undeveloped by somebody who's not a broker, somebody that does not have the expertise, and to go out to the public and to invent one after another. How many companies can these people invent? It's almost limitless. So what we have today is an opportunity to hear from a woman who was a victim of a scam by an investor with higher degrees of protection offered today, and she was still scammed for the amount of $10,000.
My name is Ingrid Robinson, and I am a victim of a fraud. Even though I initially gave this investor $10,000, I will tell you that I have been working on trying to get my money back almost 9 years. I started with the police station in San Anselmo, which is where I live, and nobody could help me. And it went up the food chain. I went to the district attorney's office. I went to attorneys in Sacramento, the attorney general's office. And quite frankly, even though it was $10,000, it was too little money to gain anybody's attention, and nobody really gave a damn. And I tried to hire civil attorneys. Nobody wanted to take the case simply because the amount of money I lost wasn't worth what it would cost me in legal fees. I even found another victim who was scammed by the same company, and my total was $40,000. And I still couldn't find an attorney or a government agency that would help us recoup our losses. And I eventually found over 2,000 victims, and $26 million was defrauded. And I can tell you, not one of us got a nickel. And if you put a cap of $5,000 and you're looking at $1 million, you're looking at 200 people. That's ridiculous. That's 200 people that will get scammed, that will get no justice and no protection, because it physically is not possible. It's not possible. The intentions are good, but the outcome, there's just nothing to protect us. Absolutely nothing. So I would vote nay on this bill.
Thank you. Next witness in opposition, please.
Thank you. I'm Scott Bernstein, here for the Public Investors Arbitration Bar Association. We're opposed to the bill. First of all, I want to compliment the committee on an excellent analysis. It hits a lot of the high points, certainly not all of them, because there are simply too many to hit. And those of us who have been in the trenches fighting for investors who've been scammed have seen it again and again. CANHR is here talking about seniors. Why? Seniors are the targets. Some reporter once asked Willie Sutton why he robbed banks. He said, because that's where the money is. Seniors are where the money is. It's not just that they have money, but they're easy marks. They're easy to, I mean, that's why PIABA members, clients, disproportionately are seniors. They talked about no meaningful recourse. Let's take it a step further. They're right. You're not going to find a lawyer to take a $5,000 case. You're not going to be able to put cases together either, because it would be malpractice for an attorney on the transactional side drafting subscription documents for one of these deals to fail to include a forced arbitration provision with a group action or class action waiver. It will provide for individual arbitrations. You want to make sure nobody gets any access to any kind of recourse. That's the way to do it. And it would be malpractice for the transactional attorney not to include such a provision, and it would be enforceable. And as you already heard, collection is going to be the big issue. The deal's upside down. The promoters are gone. They've got the money. You're not going to see the money again. So for that reason, the attorney fee shift is meaningless. It's just an attorney fee bill that's not going to be paid. We talked about we hear about the promise of jobs. There is nothing in the bill that requires the money that's raised to be used to create jobs any place, let alone in California. In fact, a California company could raise money for its business model of that it had figured out a way to compete with a California manufacturer by shipping the jobs overseas. There's another interesting thing. There's some interesting nuances. One of the items that was removed from the bill was 25104G, which was an exemption for testing. It was the testing the waters provision for offers but not sales in a non-issuer transaction. We heard in Assembly Banking about how the sponsors envision the bill being used. Well, what you envision and what actually happens in the real world can be very different things. So the fact that there was going to be an exemption for testing the waters for a non-issuer transaction suggests to me that there is very much a contemplation that the money raised could be used for non-issuer transactions. What that means is probably cashing out the promoters. There's no job creation involved in cashing out the promoters. I think there's also an interesting nuance. If you look at page 5 of the committee's analysis, there's a description of Section 25102F of the Corporations Code. This is an exemption that's been on the books since probably 1982 or so. 25102F allows much larger transactions, and the key is that you have to have a pre-existing personal or business relationship with the person you're offering to. It gets a little beyond that because there's a sophisticated investor alternative. But the key is this. You can't do general solicitation of a 25102F offering, but you can offer to people you know. This is the backdoor route to 25102F. You get 200 people at $5,000 each. And whether it's a win or a lose, it doesn't matter, because you know them at that point. And you can go to the same senior and say, don't waste your time with $5,000 deals. This is going to be good. This is the big one. You're going to get it back in more. The minimum investment's $100,000. It's the way to have the pre-existing personal or business relationship. Bear in mind, these are not venture capital deals. These are deals that venture capitalists wouldn't touch. This is seed capital. It's high risk. These are extraordinarily risky deals. And as Assemblymember Hadley pointed out last time, he said, and these are his words, there's no way for the DBO to vet these. No way for the DBO to vet these. Why? Because if you look at the size of the deal, it's look at the $500,000 deal. The fee on it, what they have to pay the DBO to vet it, is 0.4%. All right, so you're talking about $2,000. How much due diligence can you do on a speculative little startup for $2,000? You can't. So they're going to have to do an inadequate job as hard as they try. They could get a flood of these new things coming in. And worse, they're going to spend more than that. I mean, it's keyed fiscal for a reason. It's going to be fiscal for that reason and another. And that is, some of the people who lose their money are not going to be able to afford to keep paying their Medicare supplement plans. So they're going to be on Medi-Cal. It is fiscal in multiple ways. We heard
I'm going to need you to wrap up.
We heard you're always going to have scamming. Yes, you are. We'll have more of it. And California will be the place to come to do it. Thank you very much.
Thank you. Anyone else in opposition? Please state your name, your organization, and that you're opposed.
Good morning, Mr. Chair and members. Savina Tucker with the Consumer Attorneys of California, and we have a concerned position for the same reasons already stated. Thank you.
Anyone else in opposition or concerned or otherwise? All right, I'm going to bring it back to the committee. And I'm sorry, Ms. Bray, I missed the beginning of it, but I understood you were willing to take amendments 2 through 7?
Correct.
In the bill. I am still concerned, and I understand why you're bringing this forward, and there are lots of entrepreneurs who want to be able to try and raise some funding, and in fact, this might be an opportunity for a legitimate concern who appears to have a risky business, maybe not completely fleshed out, to attract some capital, thereby being more attractive to venture capital. I mean, this sort of seed funding, and if they can't attract an angel investor. But by that means, these are the riskiest of potential business ventures. And my concern is that for the legitimate ventures that we are in fact letting people know who are potential investors at this level about the level of risk. For others, I do worry that this opens the door for more fraudulent activities where somebody can come with essentially a California stamp of approval with a document that says, look, I'm licensed under the state of California. This is a legitimate business venture. So the amendments are trying to balance that out. Mm-hmm. I remain concerned with the first amendment that we asked for, because one of the control points to these kinds of transactions is a web portal or an SEC registered broker, because again, that is somebody then who has had that extra look at that potential deal and has a way of signaling potential investors. So I know you're not agreeing to take that. I'm glad that we're not allowing direct person-to-person conversations, because I do worry about somebody knocking on doors in a retirement home or a retirement village saying, look, I've got this document that says I'm legit. All I want is a few $100s or a few $1,000s. That opens the door to too much fraud. And my recommendation is do pass with the amendments you've accepted, and if you're willing to work with me to try and address my concern about just having, I'm less worried about email solicitations, but if the platform, if that business that's looking for the investments has the right amount of scrutiny, that's why, again, the registered broker or a web portal, I think is something that's important. So just putting up a website, I'm not sure gets it there. If you're willing to work with me on that as this bill moves forward, then I'll stay with my do pass as amended recommendation. But that's an issue that I'm still not comfortable with at this point.
Sure, Mr. Chair, no, I appreciate it, and we've had several conversations, and I'm definitely committed to trying to find a different solution. I mean, the challenge is if we if we just accepted the amendment, the first amendment as is, there'd almost be no reason to do the bill, because then these folks could go, through these web portals, through the feds, and the whole reason we're doing this is to provide an alternative because the costs are so high on the federal web portal. So I'm open and committed to trying to find an alternative solution, as long as that's not the solution. But if there's something in the middle,
I'm not sure.
I'm willing to.
I'm not sure what I'm suggesting at this point,
Right.
but I'd like to be able to talk about it.
Sure.
I mean, there is a reason that those costs are high. There's a reason that these are risky investments, and that,
Right.
and that we should be concerned about who may get targeted.
Sure.
And if it's some buddy willing who's got some time, who has the money, casting around through web portals or for some ideas, knowing that they're going to drop $1,000 in, knowing that they're not likely to get it back, and that's
Right.
fine, because they're excited about the potential technology, they're excited about
Sure.
the business that represents. That's one thing, but to go trolling around for folks that can be talked into an investment against their better
Sure.
judgment that's the piece that worries me the
No,
most.
I appreciate that, and I think that by accepting amendments 2 through 7, it creates I think a stronger bill and a lot more consumer protections. And I didn't really go through the amendments, but I would like to just point out a couple that I think are really important and relevant to especially the comments that were made by the opposition. And that is the first, that there will be greater disclosures on the front end. In fact, greater disclosures made to investors than is required under the Jobs Act. So I feel like the committee's done a good job in trying to create an opportunity for folks to know ahead of time that this investment could in fact be very risky, so they know ahead of time. The second is that it restricts direct solicitations except for through electronic means. That's an issue that you mentioned a little bit earlier, a concern that you mentioned in committee last time. And so we dealt with that, so we wouldn't have people going door to door and knocking on doors like we do when we're campaigning.
Yeah, look what they get.
Yeah, that is a very risky proposition every time we knock on their door.
Indeed.
But last, I think, and there are several, but the last I thought was just relevant for our discussion here, is that there's a 72-hour right of rescission. So there's an opportunity. So there's information on the front end. So we provide protections on the front end. We want to make sure we limit the way these individuals are contacted. And even in the end, if they're still not sure about the decision they made, they have 72 hours to rescind that decision. So I feel like your committee, working with our sponsors and our office, has done a great job in trying to limit the amount of opportunities that somebody could be scammed, while still providing small businesses the opportunity to gain access to capital where mainstream financial institutions are just not doing it for them. And so I feel like this is a good balance, and I'm committed to working with you on the First Amendment. So thank you.
Thank you. Thank you. All right, so other committee members, Mr. Chu.
Thank you, Mr. Chair. First of all, I want to thank the author for moving forward this very important topic. Before I became an elected official, I spent 9 years as a founder and a chief operating officer of a small business, and I can certainly attest, as can hundreds of thousands of small businesses around the state, how incredibly difficult current access to capital is. I think this provides a really interesting and innovative way to potentially access that. It's a topic that I've looked into as well, and I've certainly heard from many of my constituents of the importance of this. I don't think there's anyone on this committee that wants to see any of these mechanisms be used to engage in consumer fraud or to defraud any of our seniors, and thus I very much appreciate the author's acceptance of the amendments and the willingness to work with our chair on this. So I am absolutely planning to support this and happy to make a motion to move this forward.
Thank you.
Thank you. So the recommended motion is, let me make sure, do pass as amended, as we've talked about, and it will then go to appropriations. So we have a motion. Is there a second? We do have a motion and a second. Any other comments, questions from committee members? All right, seeing none, Mr. Prey, you may close.
Just respectfully ask for your aye vote.
Thank you. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? Wagner, aye. Alejo? Alejo, aye. Chow? Chow, aye. Chu?
Aye.
Chu, aye. Gallagher? Gallagher, aye. Garcia?
Aye.
Garcia, aye. Holden? Mainshine? O'Donnell?
Your bill is out.
Thank you very much, Mr. Chair.
Thank you. Okay. So a little bit more business of the House. I want to point out that item 7, AB 739, and item 17, AB 1417, have both been pulled from the agenda. We also have 2 items on the proposed consent agenda. Unless anyone would like to pull either of those items, I'll take a motion. So we do have a motion and a second. On the consent agenda, call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? Aye. Wagner, aye. Alejo? Alejo, aye. Chow? Aye. Chow, aye. Chu?
Aye.
Chu, aye. Gallagher? Gallagher, aye. Garcia? Garcia, aye. Holden? Mainshine? O'Donnell?
Both of those bills are out, AB 1049 and AB 1524. And it looks like we have Ms. Gonzalez here. So we move to item 18, AB 1462. Welcome.
I'd first like to start by accepting the committee's amendments and thank you for the help with this bill. AB 1462 will create a fund to help eligible Californians apply for deferred action for child arrivals, DACA, and deferred action for parents of Americans and lawful permanent residents, DAPA programs. Announced by the President last November. Our state has a compelling interest to have as many of its eligible residents seek and achieve relief through the deferred action programs. Under this bill, qualified nonprofit and community-based organizations could receive funding to assist eligible applicants navigate the DACA and DAPA application process. In the City and County of San Francisco, the Office of Civic Engagement and Immigrant Affairs created DREAM SF in response to the original DACA program announced in 2012. The program funded local nonprofit and community-based organizations with the purpose of engaging their DACA-eligible population. Grantees were responsible for ensuring access to culturally and linguistically competent legal and immigration assistance. Their program model's approach is innovative and has been successful. Replicating a similar model at the state level would create access and opportunity for approximately 1.5 million Californians eligible for deferred action programs. Finally, I want to highlight that this fund is contingent on 2 critical factors. 1, availability of funding in the Annual Budget Act, and 2, the final judgment from the courts relating to the February 16th federal injunction on the President's deferred action programs. With me today to testify is Adrienne Pond from the Office of Civic Engagement and Immigrant Affairs in the City and County of San Francisco.
Thank you. Your witnesses, please.
Thank you. Good morning, committee members. Adrienne Pond, Executive Director, Office of Civic Engagement and Immigrant Affairs. And I'm joined this morning by my colleagues, Deputy Directors Richard Whipple, Sarah Hooker, and the Honorable Haragu Gaime, who is Vice Chair of the Immigrant Rights Commission. The DREAM SF initiative was started in 2012 and is part of a broader immigrant assistance program in San Francisco where over 1 in every 3 residents is an immigrant. The program combines a total of grants and a fellows program, a paid fellowship for DACA status youth. Our total budget is $3 million for the office, and out of this we award about $1.2 million every year in community grants. That is just a fraction of what the city's total investment in is. The fellowship program provides DACA status youth with employment, job training, leadership development, and other experiences, and fellows are placed in organizations, nonprofit organizations that provide services to immigrants. We work closely with a broad cross-section of partners, including service providers and the Unified School District. For the pilot fellowship program, 80% of our fellows receive job offers. These are hardcore job offers from their host organizations, or they're continuing on as senior fellows until they matriculate from the program. Fellows also volunteer for citizenship and DACA group processing workshops and also conduct outreach to their fellow DACA applicants. And Mr. Whipple of our staff will share some of the results of our program.
Please.
Good morning. Just for some context, in San Francisco we have roughly 102,000 legal permanent residents and about 45,000 estimated undocumented residents. Bay Area-wide, we're looking at closer to 500,000. So in terms of the legal services that we provide community organizations and the impact that they have, since 2012, our nonprofit partners have conducted over 2,000 eligibility screenings for DACA and DAPA. And since that time as well, there have been about 600 applications of San Francisco residents that have been filed for DACA.
Thank you. Interesting to note, the White House Task Force on New Americans just released its report this month. And although San Francisco and California are already doing many of the recommended actions, it's worth noting that, number one, there probably won't be any new funding to states or local jurisdictions, so we'll need to be creative with the existing programs. And secondly, the likelihood that expanding federally funded immigration assistance programs to undocumented individuals is not a high priority for them. But consider that immigrants represent close to 17% of the current U.S. labor force. In 20 years, we're looking at representing 85% of the net growth in the labor force. California has an opportunity to make an investment in our most vulnerable immigrants and residents. There needs to be an investment in all Californians, regardless of their status. The highest priorities being fraud prevention, language access, English language acquisition, especially when it relates to workforce development and education, naturalization, and realistic pathways to success. Thank you very much.
Thank you. Are there any other witnesses in support of this bill? Seeing none, any witnesses in opposition? Seeing none, back to the committee for questions, comments. Mr. Chu.
First, I just want to thank the author for moving this forward and welcome our San Francisco advocates who I worked with closely over the last 6 years to help move forward local funding on this. State funding on this is incredibly important, and as I know the author knows, I am working with Mr. Alejo on a joint effort between the Asian Pacific Islander Caucus and the Latino Caucus to move forward our One California program, which would provide and really revive a program from a couple of years ago that to provide about $20 million for education and naturalization services. We know over the next 10 years, if we could naturalize California residents, the 2.5 million California residents who are eligible at this time, and another 1.5 million under DACA and DAPA, that could potentially lead to $27 billion to our California economy. So all that being said, happy to support this and happy to make a motion to move this forward.
So we do have a motion and a second. Thank you. Any other comments? Mr. Gallagher?
So my question here is, I supported your earlier bill to kind of prohibit sort of the private folks from going out and trying to get people signed up for DACA and DAPA, but I'm not sure that the government is all that different. And so, why should I support something here where we're sort of, again, I think kind of getting the cart before the horse? We don't know that DAPA and DACA are going to be found to be constitutional. They're enjoined. Setting up a new program that's going to have funding. I know you're saying if it's available, but whether or not that funding is actually going to be available is a question, and we'd be creating a new program that's going to cost money going into the future. So,
well, I want to point out that that it's also contingent upon final judgment of the court. So this program would not be established. Those are the two contingencies. One is budget money, which is in itself a tough thing in California. And the second, though, is the final judgment of the February 16th injunction. So it would not be created. And the reason I think it's important to move forward with this anyway is we don't know at what point that'll come. And I think that my last bill is consistent with that. We just don't know. But to create the framework that if it was finally allowed, and this is where ideologically I'm sure we disagree, but if it was allowed to move forward, I think we have a state interest in fact processing folks and helping people actually get the resources they need to work in California legally. We know that if you have a work permit, you're much more likely to work in not the underground economy, to pay taxes, to be a productive member of our society, and that's what we'd like. It's a benefit to the state to get that tax money in. So we want to be ready for a program if this ever moves forward out of our federal courts, and if not, then my bill, may be irrelevant, not signed, dead in the Senate. But in the meantime, I'd like to go ahead and move it forward to prepare for that contingency.
Just a quick follow-up. Can you remind me, so with DACA and DAPA, under those programs, does that actually bestow citizenship on those individuals, or is it just a right to work, a permit?
It's the right to not be deported, and it's the right to work here legally.
So it doesn't say that the person, they would still have to go through the normal citizenship procedures.
Absolutely, and right now, unfortunately, with the laws in our country, you never have there is no procedure for them to qualify them as citizens. So we would need some sort of comprehensive immigration reform for any of these folks. Our original DACA students, any new or DACA or DAPA students, we would need actually a change in our immigration policy to provide a situation where they could then become citizens. They're not jumping the line. They're not getting some extra benefit. What we're saying is, number one, if you fall into these class of folks, you're not going to be deported, and number two, that you're going to be able to work legally with a work permit.
Any other questions from committee members? All right, seeing none, Ms. Gonzalez, you may close.
I respectfully ask for an aye vote.
Thank you. The motion is due pass as amended to appropriations. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? No. Wagner, no. Alejo? Alejo, aye. Chow? Chu?
Aye.
Chu, aye. Gallagher? No. Gallagher, no. Garcia? Holden? Aye. Holden, aye. Mainshine? Mainshine, no. O'Donnell?
Needs 2 more votes. We'll put that bill on call. Thank you. Seeing a lack of authors, Mr. Alejo, are you ready to present? Lovely. You have 2 bills before us. Item number 2, AB 20, and item number 14, AB 1390, whichever order you'd prefer.